days to July, because we did not agree that we must hold the case before elections, because they want to hold us here while they are busy campaigning outside. So we said to them, we are not coming back here until after the elections. We will come back here and to sit and listen to that incompetent magistrate who comes late to court, who can't get her papers in order, who can't read her own judgments, who adjourns the court during judgment to go back seat and receive Pravin Gordon's call and receive Ramaphosa's call and receive Batoi's call. When she comes back to give a judgment, she's shaking like hell because it's not a judgment, it's a sponsored judgment. Where have you ever heard such a thing? That a magistrate lives in the middle of a judgment to go behind the court. And when she comes back, she's shaking like a little girl being asked in grade 1 to give an English presentation in front of her classmates. I know the lawyers will say, why does he speak about the magistrate like that? I don't care about her feelings. I care about the law. What does the law say? Not what the magistrate feels. Comrades, a magistrate comes to court that was postponed for so many days with papers that are all over. She can't read her own notes. Her judgment is so disorganized. Then what is even worse, there must be a separation of powers between a magistrate and the police. When she comes into court, she says to a police officer, go and fetch judgment, I forgot it in the office. The magistrate must be the only person who sees the judgment. The judgment must sit here on the magistrate. She leaves a judgment in the office. A police officer sees the judgment because the magistrate said, go and fetch my judgment. What type of incompetence is this? What type of nonsense is this that was subjected to for the past 5 years of an incompetent white magistrate? If it was a black magistrate, these people would have written about her that she's disorganized, she doesn't know how to read, she doesn't know how to write. Because it's a white magistrate, they don't say she's incompetent. She is incompetent. When she delivers her judgment, you can see that she's not sure, she's not convinced, it's not her own conviction. I don't care about my judgment. I care about the judgment of accused number 2. She amends the charge sheet from the box, from the bench, because the accused number 2 is charged for handing over a firearm to me. The statements were about him handing over the firearm to me. Everybody said when they were playing a video, we can't see him handing over a firearm. Today, the magistrate says, no, that is not the charge. The charge is supply and brought thing like that. We don't know as we stand here what is the actual charge of accused number 2. And then we must keep quiet to nurse a feeling of a white woman. We don't care about feelings of anyone. We care about what does the law say. I said this knowing very well that on the 15th of July, I'm going to appear before her. I'm not saying this here. I will say it to her because I'm not scared of her. I will tell her, you are not applying the law. The reason why you did not discharge accused number 2, you were scared of releasing a white man and leaving a black man in the dock. What type of law is that? The guy must continue to be charged because if he's released, it will look like we're persecuting a black man. You are persecuting me, whether you release Adrian or not. The reality is that you are looking for me. You don't want Adrian. You have nothing against Adrian. Release my white man and face me alone. I don't need anyone. I can stand up to all of you alone. I don't want people to die for my sins. I die for my own sins. I will never start that which I will never finish. Everything I start, I finish it.
I will move on to the heads of Advocate Matthews as far as it pertains to accused number 2. In this regard, accused number 2, the same applies. And I will try to summarize the whole version and cross-examination as placed before all witnesses and in the heads and addressed by Advocate Matthews. It comes down to the fact that count 4 and count 6 remains a statutory offence. It was confirmed in the evidence so far presented by the state that the firearm in question, being the SPA 249/14, is indeed your firearm, or the company's firearm, if I should put it in that manner. The cartridge that was picked up at the scene or close to the stage or after the incident is linked with microscopic ballistic analysis to the SPA 249/14 firearm. Much emphasis was placed on the fact that none of the videos or witnesses testified that they saw you handing a firearm to Mr. Malema. But that is not the charge. The charge is, and I will read for clarity, it's much wider. It is to unlawfully supply or in any other manner give possession of a firearm or ammunition, being the Norinco firearm and a Remington bullet to accused one. So the actual not seeing of handing over is not a requirement in terms of count 6. It is supplying or in other manner give possession. Therefore, accused 1 and 2 you may stand up, please. At this stage of the proceedings, I think the court has placed the evidence so far presented by the state on record. I have in the evidence clarified the issues and heads raised. I've tried to give reasons for the decision that I'm about to pronounce, and to add whether it is correct or not in respect of accused 1, a mere say-so that it was a movie gun does not make it so. It's not evidence, the mere say-so, in the light of the evidence that has been presented so far. I'm not saying which has been accepted as facts, but which has been presented so far. So in that light, accused 1 and 2, number 1 in respect of counts 1, 2, 3 and 5, accused 2 in respect of count 4 and 6, the application for discharge in terms of section 174 of Act 51 of 1977 is not granted.
The court pleases.
You may please be seated.
I think that is a role for this particular